So good afternoon to everybody who is on the call. Thanks a lot for taking the time today for this webinar. As you know, this is going to be specific to Canada Post terminations, but it's also going to be somewhat high level, just about what anybody's really entitled to when they lose their job. Um, I want to say just very clearly at the outset, I can't give anybody specific legal advice on this call. This is going to be all legal information. The reason is I haven't run specific conflict screens for any of you, so I can't answer questions of, what am I entitled to, or, was my termination improper, anything like that. Instead, I can give more general questions about what do certain things mean. I'm going to talk a little bit about how we calculate what somebody's entitled to on termination, but not specific to anybody's circumstance, more just sort of high level. So, in terms of the content that I'm going to cover, I'm going to jump right into probably one of the things that all of you are most interested in hearing, which is, what are my rights when I lose my job, and specifically, how is my severance or the pay that I'm entitled to calculated? Then I'm going to get into talking a little bit about, what's a termination letter and the information in there, and then what is a release and why am I being asked to sign it. I'm going to talk a little bit about high level about strategies for trying to improve your severance package if that's something you want to be looking at doing. I'm going to talk about some legal risks, including, what you have to do to try and find a new job after you've been let go. And then I'm going to talk about some other issues that are raised, especially with employers like Canada Post, who are federally regulated, including unjust dismissal, bad faith damages, and human rights related issues. Finally, I'll talk about some other entitlements bonuses, how that all plays out a little bit, and then just, some information about costs, how you can improve your package, when you might think about working with a lawyer, those types of things. And then throughout, I'm going to be happy to answer any questions you have, again, as long as it's not specific legal advice to your situation. You should see a Q&A button in the bottom. And so just if you do have any questions, feel free to dump them there, and I'll keep an eye on it as we're going. So, I'm going to start, like I said, with what are your rights when you lose your job, and just to sort of really zoom out a little bit in Canada specifically, for a non-unionized employee, there is less job protection than a unionized employee. And for the most part, if a business is looking to you know, rejig their structure, or they have a lack of work, it is permissible to fire employees. The question then just becomes, what are those employees ultimately entitled to when they've been fired? Courts have said that you always have to pay them severance or compensation when they're let go, unless certain, criteria are met by the employer. For example, they can fire somebody for what's called cause, which is they've just done something so terribly horrible that it would be unfair for the employer to keep employing them, or some other kind of exceptions along those lines. So starting point is, for the most part, employers can fire people, they just have to pay them. So when you talk about a wrongful dismissal, or some of you might have heard the term wrongful dismissal, all that means is that an employer has fired an employee without paying them what they're entitled to. If an employer fires someone and pays them, it's not a wrongful dismissal. It's a dismissal because the employer has compensated that person for what they're required to do. But until they pay the person, it's considered wrongful, but that just is the lack of pay. To figure out how much somebody is entitled to, what we do is we look at three different, buckets or sources. The first is what's called the Canada Labor Code, which is what the government of Canada has said employers have to pay federally regulated employees when they're fired, which, because you're Canada Post is a federally regulated employer. So you look at the Canada Labor Code. Second is we look at your employment contract. Do you have a contract of employment with Canada Post or your employer that says I'm entitled to X amount of dollars if I'm let go? And then third is we look at what's called the common law, which is just lawyer speak for judges. What have judges said that somebody should get when they're let go? And I'm going to walk through all three. So the Canada Labor Code is, we like to call it sort of the floor of rights, or the basic rights that every single person is entitled to if they lose their job. It sets out minimum termination pay and severance pay that when somebody is let go, the employer has to do. And if an employer does not pay those amounts, automatically they can actually be sued for what's called bad faith behavior in the manner of dismissal, which just means, doing something illegal in the way that they fire someone. What you get in termination pay is set out in the Canada Labor Code, and it is you get 2 weeks of pay and benefit continuation for everybody who has at least 3 months of service up to 3 years. So if you're 2 years, 10 months service, you get 3 weeks or you get 2 weeks. For people who are above that, they get roughly a week per year of service up to a maximum of 8 weeks. So if you have 7 years service, you get 7 weeks. If you have 28 years service, you get 8 weeks, is the way that roughly works. In addition to that, there is an expectation that the employer maintain your benefits and all terms and conditions through that period of time. In the Canada Labor Code, there is a bit of ambiguity as to whether or not they're required to do that, but there have been some cases over the last couple of years about that, and courts have consistently said benefits need to be maintained for at least that minimum number of weeks. So again, if you're a 26-year employee, you get 8 weeks of termination pay. All your terms and conditions, including benefits, should be maintained for that period of time. Secondly, you have an entitlement to severance pay. So severance pay is 5 days uh, plus 2 extra days for each completed year of service. So you start with the blanket 5 days, and then you get 2 days for each completed year of service. So that's on top of the termination pay. So those are your sort of basic Canada Labor Code rights, which usually when I say that to people, they go, well, that's not really all that much money. And actually, my employer has offered me more than that on termination. So remember, that is just the floor of rights. That's the basic thing that everybody gets. So second, what we look at is contractual rights. And a employer can, in an employment contract, set what somebody gets on termination. The sort of main rules around it is one, it has to be more than what the Canada Labor Code would provide them. You can't contract for less. So if you're entitled to, 8 weeks under the Canada Labor Code, an employer can't say you only get 4. If that's the case, the contract is illegal and you're entitled to common law notice, which I'm going to talk about in a second. So that's one of the rules. It has to be, greater than your Canada Labor Code entitlement. The other rule is it has to be agreed to by the employee, usually before they start working. So if, 2 years into your employment, the employer presents you a contract that says, we're now going to limit what you're entitled to on termination, it may not be enforceable in certain circumstances. So that's one you need specific legal advice about and your situation to get a better sense on. But that's one of the ways that a contract can be deemed illegal. Otherwise, the employer can say, well, we agreed in your employment contract you would get X. We've now let you go, so all you get is X. And it can be enforceable. However, a lot of people either have illegal employment contracts, which I just kind of mentioned, like something that doesn't comply with the Canada Labor Code, or they have no employment contract at all, or their employment contract doesn't say anything about what they get when they've been terminated. In those cases, the common law comes into play. And what judges have said is, well, if you don't have an employment contract that sets out what you're entitled to, or if your employment contract is illegal, we are going to fill in the gap with the common law, which again is just judge-made law. And judges are much more generous than the Canada Labor Code, or usually employers are in their employment contracts. And what judges do is they assess a bunch of factors like your age, your years of service, how senior your position is. Are you a senior manager? Are you mid-level manager? Are you a supervisor? Kind of where do you fall in that chain? What the job market's like? How easy is it going to be to find a new job? Do you have any special skills that would actually make it that they're so specialized that it would make it harder for you to find a new job than somebody else? Or maybe you've been working in a job so long that your education is no longer relevant, and so you might have difficulty finding a new job. But basically, you'd look at all of those factors and they sort of try and figure out how long would it take this person to find a new job. So from the date they're fired, looking forwards, what do we think this person's going to have to go through to find a new job? Which is a very sort of difficult to pin down formula. And so what lawyers and judges actually really do is they use a bit of a rule of thumb, even though they say they're not doing a rule of thumb. But anyways, they use a rule of thumb of about a month per year of service. But then we adjust that amount up or down based on some of the other factors. So for example, if you have somebody with 24 years experience, they're in their 60s, very senior position, and it's a tough job market, they're going to get at least 24 months, if not a little bit more, although there is some cases that say it has to be exceptional circumstances to go above 24. In contrast, if you have somebody who's only worked for 3 or 4 years, they're in their mid 30s, mid-level manager, and they have good credentials, they might only get, 2 to 4 months. It might be a lot lower because of all those factors. So there's no hard and fast rule in terms of calculating common law notice, but it does almost always tend to be, I mean, it is always more generous than the Canada Labor Code. It's almost always more generous than your rights under your contract. And it is usually, what most employees want is the common law notice. Um, that said, there is one major risk or deduction from common law, which is what's called your duty to mitigate. And your duty to mitigate is just lawyer speak for you have to try and find a new job, which usually when I'm saying people, you have to find a new job after they've been let go, they go, Dedoy, I need to eat. But it's actually a really important legal risk for you because what happens is, let's say, you're entitled to a 12-month notice period and you made $120,000 a year. So that's $10,000 a month. I'm just using round numbers because it's easier to do the math that way. So you're fired on, beginning of February. You would otherwise be entitled to pay for a year from that point. If 6 months into that year, you start a new job and it pays you the same amount of money, and so you earn, $60,000 during that notice period, instead of having a claim for $120,000, you now have a claim for $60,000. Because what a court will ultimately do is they're going to reduce your entitlement on termination by any money that you earn during that notice period. And that's what's called your duty to mitigate. And so, because of this rule, they impose some other obligations on people, one of which is that they make reasonable efforts to try and find a new job. So there's an expectation that you're tracking your resumes, that you're on, LinkedIn and Indeed and all those websites looking for new jobs, that you're having coffees with people in your network that might be able to help you find something, and that you have records of all this stuff. So what we encourage people to do is diarize everything they're doing, keep a notepad or something of everything you're doing to look for new work, keep copies of any applications or resumes you send out, and just keep really good notes because if you can't prove that you are looking for new work, even if you don't find a new job, a judge could still reduce your notice period. So again, let's say that person who's entitled to 12 months would otherwise get $120,000. A judge could look and say, yeah, I'm going to give you 12 months, except I think you needed to do more to find a new job. And because you didn't do that, I'm going to reduce your notice period by 4 months. So again, instead of getting 120, now you're getting 80,000 bucks because you didn't take sufficient steps to look for a new job. The other thing to keep in mind is if you turn down reasonable offers of reemployment, that can also be used against you. So again, if you're offered a job at 6 months and a court looks at it and says, hey, this is kind of roughly the same job you were doing before, just with a different employer, they could again knock down your notice period on the basis that you turned down a offer of reemployment. Now, it has to be reasonably comparable employment. So if it's, you're living in Ottawa and it's a job in Montreal that pays less money, would require you to uproot your family and do all that kind of stuff, odds are a court is not going to say that's reasonably comparable employment. But if it's for like another Crown Corp in Ottawa and it's like 90 cents on the dollar or 90% of your pay from before, and it has similar responsibilities and similar, title, a court might say, you know what, you should have taken that job. And then your claim and they basically reduce the value of your claim on the basis that you didn't take a job you otherwise should have taken. So uh, I like to flag it for people because it's usually the biggest risk that most people have when they've been let go is they might get advice from a lawyer that says, hey, you're entitled to like 12 or 24 months. But then you're going, well, yeah, but it's only going to take me like 5 months to find a new job or 6 months to find a new job. And so you need to keep in mind that your notice period is actually really probably only worth 6 months. So that's just something to keep in mind there. So roughly speaking, that's it. That's how we calculate people's entitlements. The other thing about that, though, is there is an expectation that during that common law notice period, like with the Canada Labor Code notice period, all benefits, all pay, all of that stuff is maintained. So one of the biggest things you run into, especially with Crown Corps and federal employees, is pension entitlements. Well, are they continuing to pay your pension amounts? Are you getting credit for that service during the notice period? Which, if you're someone who's like in your 60s, has like 23 years experience, and is trying to get to your sort of full unreduced rate, you might have a strong claim for 24 months, and it might be important to get that strong claim for 24 months in there to make sure that you get your pension bridge to a full unreduced pension. Because at common law, if you have a claim for common law, that is technically required. Similarly, benefits need to be maintained, including long and short-term disability benefits. That can be incredibly important because, heaven forbid something happened to you, but let's say you get sick or develop some kind of disability that keeps you out of work, but it happens after you've been fired. If the employer doesn't maintain your benefits and you would have been entitled to long-term disability benefits, you can actually sue your employer for the fact that you weren't covered by your disability policy. And it's rare cases, but they're usually pretty significant cases where you do have people who develop illnesses or disabilities after termination. Their benefits haven't been kept in place, and then they need them, and they end up having very, very significant claims against their employer. So that is one of the essential things that needs to be maintained. Similarly, bonuses, variable compensation, anything that's not base salary is usually needing to be maintained, although it's a fact-specific thing and it depends on every single person's situation, how much it fluctuated, how regular it was. Is there something that says it will be paid after termination? There's a bunch of things we have to look at to decide whether or not a bonus or variable compensation is included as part of the notice period, but more often than not, it is. But like I said, that's an individual situation thing. So roughly speaking, that's how you calculate what somebody's entitled to when they've been let go. I actually think it maybe makes sense for me to move on to some of the other claims people might have, and then I'm going to sort of circle back to what's a termination letter, what's a release, all that kind of stuff after that. So, one of the sort of unique aspects of the Canada Labor Code is it has what's called an unjust dismissal regime, which basically means outside of some exemptions, employers cannot fire an employee unless they have cause, which is, like I said at the beginning, a really, really good reason to fire somebody without compensation. So negligence, chronically poor performance that's been documented, performance managed, and despite that, the performance hasn't improved. Fraud or theft, like things that are more serious. And if an employer fires an employee who's federally regulated without cause, the employee can bring an unjust dismissal complaint, you know, but there are some exceptions that I'll get to in a second. Because of this right, it gives employees a couple of other things that they can do. First is they're entitled to ask about the reason for their termination. So if somebody's fired and they're kind of like, this seems a little bit off, I think I don't think this was actually a legitimate termination. I think they've done something improper. They can write to their employer and say, I want to know what the reasons are for my termination. And that's a right that they have under the Canada Labor Code. If they think it's an unjust dismissal, they have 90 days from the date of termination to file an unjust dismissal complaint. This is a hard deadline. And so if you are thinking that there's something that might be, off about your termination, which we'll get to in a sec, you need to make sure you respect that 90-day limitation period. Third is you have to have 12 months of service. So if you've only been working there for 6 months, you can't bring an unjust dismissal complaint. You need to have 12 completed months of service. But the sort of really important things for you is there's two other limitations. The first is you cannot bring an unjust dismissal complaint if it's a lack of work or discontinuance of function. So right now, Canada's Post is saying this is a big restructuring. We're getting rid of a lot of people. We don't have, work for many of these people, and that's why we're doing this. And that may or may not be legitimate. We need to look at each person on a specific case specific basis. But where it is legitimate, if it is a hey, look, we're just coming off this strike, our volume is lower, we have too many employees, and we need to reduce things, that might be proper. But if they do that and then they go, you know what, this one person's been on medical leave for the last 6 months, we're not sure if they're going to be coming back, and so we're going to get rid of this person because they're on medical leave, then all of a sudden that might turn it into an unjust dismissal because it's not actually the downsizing that's the main reason for the termination. It's because of the disability. Or that it is somebody who has been accused of some kind of workplace wrongdoing, they're investigating it, and then they decide, you know what, instead of investigating this and finding out if we actually have cause to fire this person, let's just hide it as part of this downsizing and we'll get rid of them that way. So in cases like that, there might be a unjust dismissal claim that is worth looking at because an unjust dismissal claim can get you reinstated. So one of the remedies you can seek as part of an unjust dismissal claim is both back pay and reinstatement and a bunch of other damages. And so when people do have credible unjust dismissal claims, it often gives them a lot more leverage in negotiating a better severance package from the employer. Because if the employers let that person go, they really don't usually want to hire that person back or be forced to hire the person back. So it just gives you a bit more leverage to negotiate a package. So the first exception is, like I said, a lack of work or discontinuance of function. The second exemption is managers can't bring unjust dismissal complaints, which you're probably going, well, why is he talking about this? It's mostly Canada Post managers who have been let go. However, the Canada Labor Code unjust dismissal regime uses the word manager very, very specifically. And really, it's talking about people who have significant degrees of power, or power of independent action, autonomy, and discretion. So just because you can performance manage people or you can hire people or you have some managerial functions, that doesn't necessarily make you a manager for this purpose. You have to have like a significant degree of autonomy. Really, you have to be in a very core HR, management function to actually be called a manager under the Canada Labor Code. And so I'm smart money says there are a good chunk of managers who have been let go by Canada Post who do not meet the definition of manager under the Canada Labor Code. And if they could show that their termination was improper some way, like I said, if it was discriminatory, if it was a ruse to hide another reason for terminating them or something like that, you may have a credible unjust dismissal claim. But again, I can't get into specific details about your specific situation. This is just more high level kind of legal information about what you might be entitled to. Similarly, you might also be able to bring a human rights claim. So again, if you were sort of pulled up into this group of managers and you think it's because, well, hang on a sec, I made a complaint a month ago because my manager was harassing me based on my race, you might have a human rights complaint and an unjust dismissal complaint. And for you, that would be either you bring an unjust dismissal complaint or you could bring a Canadian Human Rights Act complaint. And for a human rights complaint, you don't have to show that the human rights issue was the only reason you were terminated. So you don't have to say, I was fired because I made a complaint of racial discrimination. You don't have to prove that. You just have to prove that the complaint of racial discrimination tainted the decision to terminate. So if there's a legitimate downsizing, like they are needing to legitimately reduce their workforce, but you were only picked because of the complaint, just because it's a factor in the complaint means you might have a credible human rights complaint. It doesn't have to be the overarching or the only reason for the termination. It just has to taint the termination, or one of the other expressions people use is, does the termination have the subtle scent of discrimination? So other times we see it is employees who are on mat leave or about to go on mat leave, that sometimes employers go, let's just get rid of that person because we don't want to pay for them to be on leave when we're saving money. Or they've, brought in a replacement while somebody's on mat leave who costs less money, and so they try and use a business reorg as a, way of disguising the fact they're actually firing someone because of the fact they took a mat leave. Things like that could be a credible claim for either unjust dismissal or human rights. Similarly, you can also bring a claim of what's called bad faith behavior in the manner of dismissal. So courts have said that, the way you fire someone matters. And if you are you're not truthful, you're dishonest, you act in bad faith, you make, allegations of misconduct that aren't real. Like really, if you don't do anything that's really sensitive to the fact that a person's going to be very vulnerable when they're fired, an employee can always bring a claim for bad faith behavior in the manner of dismissal, where what courts are compensating you for is a damage to your health. So if the termination has a significant impact on your health, you can seek damages for that, or damage to your reputation. So if they go and badmouth you in the job market and it makes it so you can't find a new job, you can bring a claim for the impact on your reputation. There's also a way to go after punitive damages, which are to punish the employer for bad faith behavior. That's usually a really high threshold to get there, but it is also something you can look at. But again, that is a very fact-specific situation. So, very, very high level, those are the types of things and the types of claims that somebody who's been let go are looking at. And so, my understanding of most of your circumstances right now is you have been let go, you have a termination letter in front of you, and you have a release in front of you. And so the termination letter, for the most part, is just setting out, this is what we're going to give you because you've been fired. Usually what it'll have is the first section, which sets out, these are our Canada Labor Code minimums that we have to maintain. So it should have maintenance of pay, maintenance of benefits for that, week per year of service up to a maximum of 8 weeks that we sort of talked about. Usually what it'll also have is what's called a without prejudice offer to settle. And that is almost always more than the Canada Labor Code minimum, but they're usually asking you to sign a release, and it's usually time limited. So it usually says, if you don't sign it by, 2 weeks from now, we're going to withdraw this offer. So Just to let you know, that timeline is generally artificial. It's the employer puts a timeline just to make sure people get back to them. And you can usually ask for more time if you need more time to get advice, to think about it, to do whatever. And so you just ask them for more time. And frankly, usually if the employer's saying no, it's a good sign that they are doing something unfair. If the employer's being fair, then usually they're happy to give somebody more time to go get advice because they're hoping the person will go get advice that says, yes, the severance package is fair, you should accept it. So it can be sometimes a bit of a good barometer to kind of tell if the employer is being fair with you or not. Um, but that is, at a without prejudice offer. What without prejudice means is you can't use it down the road if you decide to sue Canada Post. So you can't go in front of a judge and say, "Hey, when they fired me, if they fired after they fired me, they offered me more than my Canada Labor Code minimums. Therefore, I'm entitled to more than that." A judge is going to say, no, that was a without prejudice offer, which means you can't rely on it. So that's really what it means. It's not evidence. You can't do anything with it. The release is you releasing all of your legal claims. And that's probably one of the most important documents you would sign and give back, because once you have signed that and once you've returned it, there's almost nothing a lawyer can do for you about your termination. And so that is why we always recommend that, or not recommend, we insist that people get advice before they sign their release and return the termination documents. There is almost nothing we can do for you if you've already signed that release, because you are giving up your right to pursue any claims against your employer or against Canada Post. I saw one question, which is if someone is terminated within their probationary period, can they bring an unjust dismissal complaint? Good question. No. You need to have at least 12 months of service before you can bring an unjust dismissal complaint. Similarly, there is a bit of a concept of about a 3-month probationary period where you don't even have a right to Canada Labor Code damages within your first 3 months. There is a lot of autonomy for employers to fire people during a probationary period, and basically the only exception to it is it discriminatory? There might be some other ways you could get around it, but the main one would be if it was discriminatory. So if you're in month 2 and somebody made a racist comment to you in the workplace and you complained about the racist harassment and then they fire you, you'd probably have a credible human rights claim, but you couldn't bring an unjust dismissal claim. You'd be stuck with a human rights. But yeah, that's a really good question. Um, so like I said, just to kind of start to put a bow on this because we're sort of hitting the time limit. The release is incredibly important. The other thing that the release will likely include is a confidentiality clause. And the confidentiality clause is going to say you cannot talk about the settlement with anyone. What that generally means is if you repeat it to somebody else and then they go back to Canada Post and say, hey, Jim told me he got 12 months. Why did I only get 8? Then Canada Post might either rescind the termination offer, they might sue you for breaching the release and breaching the confidentiality, and frankly, just be really upset because they don't like to know, or they don't like employees to know what each other are getting, especially if they've offered some people more than others, because then that's what happens is then they say, hey, Joe got that. Why aren't I getting that? So that's just something to be very careful about before you sign the release, is that you know what you're signing. I saw another question in the Q&A, which is if I secure a 12-month payout and I find similar employment 6 months down the line, do I have to pay anything back to Canada Post? I'm going to give the very lawyer answer of it depends. So first is if you haven't signed a release yet, so if you haven't returned the package and you sue Canada Post and you find work at 6 months, you don't have to proactively disclose to Canada Post in litigation that you've found new work. However, they will ask, and when they do ask, you can't mislead them. So you would have to tell them, yes, I found work at 6 months. So practically speaking, they're going to say, well, we're not going to pay you at 12 months now. Only going to pay you 6. If you have signed your severance package back and the severance package was hypothetically for 12 months, if the severance package says there'll be a clawback or there'll be a reduction from the damages, then you'd have to pay it back. So if the severance package says we will give you 12 months, but if you find work before the 12 months, we'll only pay you out the difference between your old salary and your new salary, then yes, you would have to pay it back to Canada Post. If it doesn't have any language to that effect and you sign off the termination letter and then you start working the next day, Canada Post is out of luck. You get to keep your severance package and you get to keep money from your new job. But again, you'd want to, it'll depend on the specific wording of your termination letter as well as your release to decide, do you or don't you get that? So yeah, I think that sort of answers that question. So finally, where do you go from here, or what do you do from here? And people have a ton of options because they're looking at this and maybe they think, this is maybe fair, it's maybe not, I don't really know. And so our standard advice is obviously get legal advice on it, especially for some of you who are more senior and whatnot. You might be looking at, $100,000 to $200,000 payment if you are a long service employee who's making, over $100,000 per year, and you're getting, 16 months, 18 months, whatever it is. I kind of think it's like a house inspection. Like you don't buy like a $200,000 property without somebody going and looking at the foundation. It's sort of like that even if it is fair, it's usually good to satisfy yourself that it is actually reasonable. But the second is, we and people have all sorts of ways that they negotiate improve severance packages. Sometimes they do it themselves. They know the HR person, they have a good relationship with the HR person, and they go, you know what, I just want to sort of resolve this informally with you. Can you do X, Y, and Z? And if so, I'll resolve it. Some people work with a lawyer where in the background the lawyer just kind of ghostwrites things and does sort of the same thing, but you have the benefit of a lawyer who sort of makes sure you're on the right track and not doing anything silly or that's going to sort of compromise your rights. Third is people retain lawyers, and lawyers send what's called a demand letter, which is just a letter that says, "Hey, you haven't paid my client properly. They're actually entitled to this. Let's discuss settlement." And then the lawyer just handles the negotiation of the settlement. Um, you know, the cost varies of all those things. Obviously, if you're working by yourself, there's no cost. If you're, working with a lawyer sort of informally, it can be a few $100 to a couple $1,000. And then if you're trying to negotiate a better severance package with retaining a lawyer, it's usually in the range of 4 to 6 thousand bucks. It can be less, it can be more. A lot of it depends on how complicated your case is, how responsive the employer is. Is there human rights issues or are there other things that complicate it? It really does depend, but that's kind of the range most people are looking at. And often, but not always, employers will cover the legal fees if you can ultimately get it resolved. We can never guarantee it. It's more often than not that they do it. And it's usually only in cases where what's been provided on termination is unfair. So if they've given you something fair, we send a demand letter and all because you've decided you want more, but our opinion is actually this is fair, and they don't improve it, the odds are Canada Post is not going to offer to pay your legal fees. But if they did do something unfair, or they did something improper, and there is an improvement, then in those cases, then usually the employer is willing to pay legal fees. And we or any lawyer would always give you an opinion at the outset of like, yes, you should do more, or you should accept this. We don't think we can do better. That's part of the sort of when I say checking the foundation, that's really what it is this fair to me? Should I accept this? What are my risks? How much is this going to cost? It's all those types of things. But long story short, that's kind of it. Um, I saw a question about reduced lawyer costs based on volume. So one thing that we do right now, actually, this is a new thing we just added last year, is we do a fixed fee severance package review now for not just Canada Post employees, but for all employees. So assuming it's just a, hey, can we get my severance package reviewed? For $595 plus tax, what we do is we just fix that fee. So if, it takes me an hour to review your documents and then we meet for 90 minutes and whatnot, normally that costs my rate is $400 an hour. So even if it's 2.5 hours, you're looking at, $1,000 or whatever plus tax. We have fixed that initial meeting at $595 to do the initial assessment with people. And so that's kind of the like we don't just do it with Canada Post, we do it for all employees as long as it doesn't have something complicated. In terms of reducing the like rate, what we don't do is we don't reduce our rate, but sometimes what happens, especially when there's been group terminations, is we work with individuals to try and resolve as many of them individually as possible because most of you will have your own situation that has to be resolved. And then if there's a handful of people that are left over at the end, that haven't gotten a resolution, we can often look at a group action. So it can be like we've resolved 10 of these, but there's 6 employees who, Canada Post didn't do something fair with, and so they get joined together and sue Canada Post together because there's some economies of scale. But we need to make sure the files are similar enough that we're not going to get into trouble from the court about doing that. There's certain rules to actually bring a group claim together, but that's generally the way we do it. And then, yeah, it does tend to save people a lot of money because the statements of claim are mostly the same. We're dealing with the same lawyer. We can do group sort of hearings and whatnot. So it tends to save people pretty significant money, but it isn't really that helpful at the front end. Other than where you do end up saving money is like, let's say I have four Canada Post employees. Instead of me having to have four calls with Canada Post, we're going to have one call. We're going to talk about four people. And so that tends to be a lot more efficient. And so there is sort of savings there from economies of scale. But that's roughly how it works. So just looking at my list, that was kind of everything we wanted to go to. And I realize I've gone a little bit over the 30 minutes.